Friends, as you are aware that this is our 178th webinar. We have concluded 177 webinar in last 4 years. More than 123,000 people registered, participated in these programs with 250 panelists across the country on different field, maybe judge, parliamentarian, the regulator from MCS, CCI, SEBI, IBBI, former regulator, professional from the industry, practicing professional. So all have come here and they have shared their knowledge. The purpose of this program is to, whatever we have learned, whatever we can create an atmosphere of knowledge, we are just creating. Friends, recently, today's topic is very, very important. And though it is a 5 years old, but still there are so many confusion. And whenever there is a new order passed by the ROC, then the issue again come up. So today we are discussing about this issue relating to SBO on recent cases finalized by ROC. So friends, recently ROC has started adjudicating penalties for numerous companies under Section 90 of the Companies Act 2013. Section 90 of Companies Act provide for a declaration to be given to the company by every individual acting alone or together or through one more person who hold the beneficial interest of not less than 10% in shares of a company, or the right of the exercise or the actual exercising of significant influence or control over the company. Now, this is the Section 90 says. Though 5 years has completed when this notification came, it has not come with the Companies Act 2013, but it has come after 5 years or 6 years after the launching of the Companies Act. And companies are still facing difficulties in identifying the SBO in certain specific situation, and various interpretive challenges surrounding Section 90 and the SBO rules are also there. That's why this webinar we are organizing to discuss the key issues related to SBO provisions and advisory issued by MCA, because MCA continuously giving advisory on various aspects. So today what we want to discuss in the key area: origin, implication and complexity of identifying of SBO. Now, though no doubt it is now 5 years old, but even if the correct and today's interpretation after so many clarification, what is the total identification of SBO? How to determine SBO? Compliance requirement for disclosure of SBO, implication of non-compliances. Now, these are the topics which we want to discuss today. Today, we have requested and invited our guest of honor, Mr. Santosh Kumar. He is a Indian Corporate Law Services Officer, currently serving as the Regional Director of the Western Region of Ministry of Corporate Affairs. Then we have a Vinod Sharma. He is Indian Corporate Law Service Officer, currently serving as the Regional Director of Northern Region of at Ministry of Corporate Affairs. These are the two stalwarts are there, those who are making law and explaining this. Both are busy in their ministry meeting. So as soon as they will be free, they will join us, and they are happily accepted our invitation to give answer of the various questions. So when they will join us, we will ask the questions and the issues. So everybody and anybody has any point, please write here in the box so we can ask them. Then we have 3 more speakers. One, Dr. Akhil Prasad. He's a Director, Country Council, India of Company Secretary, Boeing India Private Limited. Boeing is a MNC company, and they are also having the same type of issues which we have faced recently seen in LinkedIn and Samsung. So I welcome Akhil he is one person who is having a very wide experience of 25 years in House Counsel and worked with legal team spread across different countries and different segment he has worked. Then we have Ankit Singhi, Head Corporate Affairs and Compliance, Corporate Professional. I welcome Ankit and Akhil both. Then we have Nitesh Latwal. He's Associate Partner, Corporate Affairs and Compliance, Corporate Professional. Friends, these all people, those who are in practice, will tell us about various things. Recently, we have seen two judgments. One is the order passed in the LinkedIn and Samsung, and both order in the market has created a havoc, especially in the MNC sector in various Indian corporate. So these issues which we want to discuss today, want to understand why, what are the points, what are the issues which we have to see. So first of all, everybody should understand, though it is old thing, but I'm just taking you to this part that as a layman point of view, what is SBO? Because SBO is a person who significantly control or influence over the company, even if he is not directly listed as an owner of the or the shareholder. So you may be SBO, but you are not having a shares, you are not having a name as a director, but indirectly you are managing entire thing. So the purpose of this law is that whatever structure you have created, whatever things you have created, ultimately who is behind this, who is the natural person should come out. Companies Act 2013 also require to identify and disclose these individuals to ensure transparency and prevent misuse of corporate structure. As an SBO is generally someone who knows or control a certain percentage of shares or voting rights in a company, either directly or indirectly. So you have seen that in India also, across the world, we have a web of companies, and the purpose of web of companies is multiple layer is there. Earlier, there was any limit, any layer you can do, but after the Companies Act 2013, they have restricted the layer to 1, 2, 3, and certain cases. So not going beyond this. Earlier, you can have a 10 layer also. So that web of companies people were making for tax planning, people are making for some other benefit, legitimate or illegitimate, or various other aspects that was there. So SPO is a hidden or indirect owner who has substantially control over the company, and the law requires companies to report these individuals to maintain transparency. So the point is, ultimately, this law has come to show the transparency in the business, because the concept is very clear. And sometime when the law came, then Indian corporates opposed this, and they said that this is a new compliance and this is a new things which has come. But if you see the other part of this, it's not unique in India. Globally also, this is this is always to enhance transparency in corporate ownership, and they want to prevent misuse of corporate entities for illegal activities like money laundering, tax evasion, financing terrorism. So you can understand that this concept is not by Indian law, it is an international concept, and that has come out. And the primary goal, which I have told you, it's a being transparency. Who is ultimate owns or control the Indian company? So real owner should be known, and even if they are hidden behind layers of corporate structure. So the purpose is, you have one layer, second layer, companies holding another company holding another companies. It's a cross holding are there. But ultimately, who owns this? If you go and see this, the web of the companies, you will not find this. So that's why the people are taking advantage of this process. Now, if I see this, that why this law has come. So globally, the international standard has set up, and Financial Action Task Force (FATA), FATF, which provide guidelines to combat money laundering or terrorist financing. Now, this is the basic example, and that's why in United States, The Corporate Transparency Act requires corporate limited liability companies and other similar entities to report their beneficiary owners to the Financial Crimes Enforcement Network, that is FinCEN. So, people, when it came to India, people opposed this, but ultimately this is not correct situation. This is like this, that in United States also they are following. European Union, it is implemented the fifth money laundering directive, AMLD, and in this directive they have asked the companies or all the members to maintain central register of beneficiary owners information. Same concept, but the process is different. Then UK also has a people with significant control register, that is called PSC, where companies must disclose individuals who have significant control over this. So these measures are a part of the broader international efforts. It is not just a part of the some compliance part of one regulator. It is an international affair. And to ensure they identify the individual and ultimately beneficiary owner of the companies, and that bring transparency and possibility to the regulator, that what is who owns this company and who is the real owner. Recently, two cases, LinkedIn, you have seen that issue came. As per the definition, this is happening, that they are coming to this category. Second is, another aspect is that Samsung case, where they have given the names of their CEO in India, and they have given in the bank, ultimately beneficiary owner in the bank. So that's why the ROC has passed an order for this Samsung in India also in the same manner. Now, so many companies are opposing this. They say privacy is affected, increased compliance cost is there, potential misuse of information is there. Then they say regulatory burden is additional aspects, complexity of implementation is there, risk of non-compliance is also very serious. So these are the points which corporates are always giving. But friends, the advantage of SBO is also multiple. One is this is international commitment. Second is it enhances transparency. It is a combating illegal activities, because who is behind this, you cannot escape by doing this. Improve corporate governance. Investor confidence also increase that this is the person behind this. And regulatory compliance is also one part. And reduction in corruption is another part. So you can understand this concept is not new. Across the world, it is happening. I remember when this law came, and I met one very big listed companies who are our client, and I asked them. So they said, because they have an international office also. When I was asking that why the corporates are opposing, so that person told, that company secretary told me that it is in India, it's very simple, but in the other part of the world, you have to explain everything in detail. So the point is, everybody should understand that this is not a part of the law only, this is a part of international commitment, and this is a part of the creative transparency and good governance practices, and avoiding multiple wrong policy, wrong things which people are following under the web of companies. So friends, today we will discuss all these points, that what are the problems in this, how we can do implementation, what are the implementation problem, what law has reached to which level. All these points we will discuss, and after the discussion, we will we'll take the question answer. And we have a Dr. Akhil Prasad Desai. He has a experience of national companies in multi-jurisdiction. So we'll understand his experience also, and experience relating to that what he thinks about this particular thing, and how tough Indian law versus the international law. Friends, this journey of knowledge we are sharing with you, and this is the object, that wherever there's a new law comes, wherever there's a new law in the beginning, in the process, so we want to create the best minds should come together, and the people should give their opinion, and we can do something good for the corporate world. So in the same direction, our next webinar 179 will be on SME IPO on 5th July 2024. We will organize this and we'll invite the experienced people from this industry. Now the program structure is first Nitesh will give a presentation, and then I will request Akhil Prasad to give his opinion about this particular concept and his experience. And then we will have a question answer session. And in between, Mr. Santosh Kumar and Mr. Vinod Sharma joins. We will ask them their comments, and then we will request them to take the question answer. So with these things, I will request Nitesh to give his presentation on this SBO and explain with the new things and interpretational issues. Everything should be part. Over to you, Nitesh.
Good evening, sir. Good evening. Good evening, friends. Today we are here to discuss about the nitty-gritties of the SBO and the major challenges faced by the company in identifying the SBOs, considering the recent SBO orders filed by various jurisdiction of the Registrar of Companies. So first of all, I want to make it clear that we are not here to criticize any order. We are just here to criticize any order or any ROC order. We are here to analyze the order, to ascertain the gaps, to ascertain the kind of the kind of in the order, if there's any discrepancy between the rules and the stand taken by the ROC in their respective orders. So we are not here to criticize any order. It is just to ascertain the gaps, finding precautions what the company can take while identifying the SBO, and to take such steps after making a due diligence. In if they do not find any kind of SBO in a company, they have what records they have to maintain. So here we why SBO? As I already told that recently the orders have been passed by various ROC of different jurisdiction, majorly New Delhi office, UP ROC, and Chandigarh ROC, and there are a couple of ROC orders as well. So in this presentation, we will be discussing 4 orders, majorly the hot topics during the day, during these days. That is LinkedIn, Samsung, IDER, and Lexer Resources. So first of all, we need to understand that who is SBO. What are the rules provided in the Companies Act, which provides or the obligation of the company to identify the SBO. So first we need to understand who is SBO. So SBO means, first of all, he must be an individual who either acting alone or through any body corporate or any entity, if they are having minimum 10% of shares or voting rights in a reporting company. Here means reporting company means a company which is under the obligation to identify an SBO, which must be an Indian company incorporated under the Companies Act. So that person through either through a loan or through any body corporate must have at least 10% of share or voting rights, or having a right under distributable dividend or other distribution, or he has a right to exercise or actually exercising a significant influence or control. So significant influence is also defined under the Companies Act, which means you have a right to participate in the policy decision making and need not to have any board seat, but you have a right to participate. If you have a right to participate in any major policy decision making, then you are it shall be deemed or considered that you are exercising a significant influence. And control is also further defined under the Companies Act, which says that you have a right to appoint majority of the directors. You have a right to actually have a right to not only participate, right to have a you have a right to actually formulate the policies, or you have a right to actually dissent with any of the policy making of any company. So it constitutes a control. So so the next step is here are some example where we find out that who can be a SBO. So there's one example in X Limited. X Limited, that is a reporting Indian company in which Y Limited holds 10%, and that Y Limited is majority owned by A Limited. So in that scenario, Mr. A shall be the SBO of that company, since Y Limited owns majority of the stake in Y Limited. So another example, there's change some in this very example, that if X is a reporting company, in the same fashion Y holds at least 10%, and in that Y Limited, Z also holds some stake. It could be a holding company of a Y Limited. If that Z Limited is owned individually by Mr. A, B, and C, if they are having different stake in the Z Limited, if one of the person is owning a majority, then that person becomes a SBO of X Limited, that is a reporting company. If situation are in a manner that some if we change the shareholding pattern of Z Limited, makes Mr. A Limited holds, like for example, 33%, and Mr. B Limited holds 33%, and Mr. C Limited holds the rest of the 34%. If nobody is owning majority of the stake in Z Limited, then it cannot be considered that anybody is a SBO of X Limited. But there's a situation that somebody say that Mr. A, B, C are collectively or acting together. If somebody, or if they by themselves says that we are acting together or in concern, then Mr. A, B, C, irrespective of their shareholding, even if it falls below 50%, they become the SBO or significant beneficial owners of X Limited. So we need to understand that in the ultimate holding company, there must be some majority shareholding. If nobody have a majority shareholding in that ultimate holding company, then we need to see that who all are the shareholder, and whether the majority shareholding is either a group of individuals owned majority, then all those persons who are acting in concert becomes the SBO of that reporting Indian company. So there is another more concept called pooled investment vehicle. So as we know that in MNC culture, that most of the investments, most of the stake is owned by a pooled investment vehicle. So where there is a member of a reporting Indian company, is pooled investment vehicle or any body corporate which is controlled by a pooled investment vehicle, then in that case, SBO could be a general partner of that pooled investment vehicle or an investment manager of a pooled investment vehicle, and where the investment manager generally just like in India that there is a called AMC asset management company who generally is a body corporate. If that parameter is same as a investment manager, they are treated as investment manager. If that investment manager happens to be a body corporate, then in that scenario the CEO of that pooled investment vehicle becomes a SBO for that purpose. Now we take the example of what constitutes significant influence. So significant influence, as I have already mentioned, that he has a right to participate or power to participate directly, indirectly in the financial and operating policy decision of the reporting company, but does not have a control. So it excludes control. But if you happens to have or you have the right to participate in the operating policy decisions, then you will come under the radar of SBO and you will be considered as a SBO. Like in this example, that there is a foreign investor Y which holds 40% stake in the subsidiaries of X. So the Y exercise, if the Y has a right to appoint, let's suppose, a director in the subsidiaries, or his presence is necessary to form a quorum, then if you have a director and though that director does not have on its own can pass a resolution, but they have certain right with respect to quorum or with respect to affirmative right, then such kind of disease or such kind of rights become a significant influence for that purpose, and that very foreign investor in this case becomes a SBO, and which who requires to file a declaration with the company. Now we'll talk about the control. So control as defined under the Companies Act says that it shall include right to appoint majority of the directors or to control the management. Here it does not mention participate. It says that you need to have control. You need to have control over the management and policy decisions exercisable by a person acting individually or concert, whether directly or indirectly, whether through any shareholder agreement or any other agreement in any manner. Need not be in writing, but by the acts or circumstances, if it seems or it consider that you have a right or you are exercising the right to control the policy decision, then that you will be considered that that subjective company is under the control of you, or an individual either acting alone or in concert. Here in this case, that Y Limited exercise the following rights in the subsidiary: right to appoint majority, which we generally have it in a group setup, where we have a certain rights like right to appoint directors, right to appoint auditors, right to approve all the material policy decisions. Then that person which is at the ultimate holding company exercising such rights, then that person deemed to be exercising control over the step down subsidiaries or reporting Indian company. Then that person is required, in this case the foreign investor is required to make a declaration to the Indian reporting company. So we need to also understand the concept of beneficial concept of holding beneficial interest through any other person. When we say that when we say the SBO definition says that if any person uh, is having a stake either through himself or herself or through any person. Now, the any person could be a body corporate, any entity through which you are exercising a control or exercising significant influence. So in that case, you also be considered as a SBO for this under the SBO rules, and you require to file the declaration accordingly. So in this case, let's suppose C Limited is a reporting Indian company wherein B holds 100%, and in B Limited, A Limited holds 100%, and in A Limited there is there's a different individuals, and there's a different individual holding 33% each. If XYZ are, if they are acting in concert, then they all become they all become the SBO of the reporting company, that is C Limited. So here a person means A Limited or B Limited, where you are exercising control or significant influence in C Limited. So the person here is the A Limited and B Limited. Then in next situation, there's a Mr. DD. There's a Mr. DD which put in fund in A Limited, and which XYZ managed to get it from Mr. DD. So, and Mr. DD reserve any right that they work according, or they operate the step down subsidiaries or their subsidiaries as per the instruction of Mr. DD. Then in this case, the Mr. DD will become a SBO for C Limited, since it is as per the instruction of Mr. DD. XYZ is making decisions. So in this case, XYZ, Mr. X, Mr. Y, and Mr. Z will not be a SBO, but Mr. DD will be a SBO for this purpose. If such rights gets invoked at any time, then Mr. XYZ automatically become SBO for C Limited. So there's one more concept, holding reporting company. So holding reporting company means if there's an Indian reporting company which is a subsidiary of another Indian reporting company, which in itself is subjected to this regulation, and in that company there's Y Limited, which is the ultimate holding reporting company, and in that company Mr. A holds entire stake. So in this case, uh, B will file band 2 with the ROC declaring Mr. A Limited as a holding reporting company, and in turn, Mr. A Limited will file band 2 declaring Mr. A as its significant beneficial owner. So if I conclude this, that holding reporting company means a company which in itself is a intermediary reporting company, intermediary holding company, which is not required to file a detailed declaration. But if they only declare if they only declare a simple declaration that reporting company is B Limited, then from that they need not to file. It means they are not supposed to file a detailed declaration, taking again declaration from Mr. A Limited. If Mr. A Limited files a declaration to B Limited, that's sufficient compliance, and A Limited declares a simple declaration that it's a holding reporting company of B Limited, then that is a sufficient compliance. Need not to take another declaration from Mr. A for A Limited. So, we have discussed what is provided in the rule. So there are certain challenges in identification of SBO which every company come across. The first one is that, as we discussed, that there are a group of person. There's nobody who owns majority stake in a company. or in a holding company or ultimate holding company. So it's very difficult to identify. So unless until there is a very concrete uh, there's a concrete material on records that they are all acting in concert, then it is very difficult to identify SBO. The second is if your ultimate holding company is a listed company, and there are nobody who owns a majority stake in that company. There are a largest shareholder, but there will not be any controlling shareholder. There will not be any shareholder who controls more than 50%. And the next challenge would be that there is a interlocking of shareholding between the company. As we already know that in a group of companies, there is a interlocking of shareholding between them, and nobody is a subsidiary of each other or a holding company. So they are structured in a manner that it is very difficult to find out who is a SBO. So now we analyze the recent ROC orders, the four recent ROC orders which the different ROC have passed. First of all, the LinkedIn case. The LinkedIn case is a first case of its kind where the ROC Delhi has levied penalty through adjudication process on the CEO of Microsoft, that is Satya Nadella. So they have found that Satya Nadella, or a CEO of Microsoft, is a SBO in this whole structure. Here, the LinkedIn India is a reporting Indian entity which is ultimately owned and controlled by Microsoft USA, Microsoft Corporation USA. So there are more facts we need to analyze. That Mr. Nadella is the chairman CEO of Microsoft Corporation USA, and there is one more person who serves as a global CEO of the LinkedIn division. The structure also includes that LinkedIn Corporation being owned, controlled by Microsoft, and where Mr. Roslansky is an employee and the global CEO of LinkedIn Corporation. The LinkedIn Corporation USA is shown as a holding company in the financial statement of the reporting company, that is LinkedIn India. And we also find in the order that Mr. Roslensky, who is a CEO of LinkedIn division, reports to Satya Nadella. And there are more material facts which says that some of the employees of Microsoft Corporation, also the employees in the past, or they are presently the directors of LinkedIn India. And there's one more thing the ROC noted, that that in the board meeting of reporting Indian company, that is LinkedIn India, some non-board members are invited from Microsoft Corporation USA. And one more factor they have ROC has taken into consideration, that the bank accounts of the Indian company is being operated by the employees of Microsoft Corporation USA. So here, the conclusion is that on the basis, the observation, the consideration, the notes on the grounds on which the ROC concluded that Mr. Nadella as Rosensky is a SBO in LinkedIn case. They have found out that the employees of Microsoft corporations are the directors of LinkedIn India, which always which shall be considered as a nominee director. Authorization of bank account from outside India means that you are exercising control over the financials of the company. there are some visits by the CEO of LinkedIn India and Microsoft where they discuss about the future plans. They have a discussion with the employees, the top level employees of LinkedIn India. They have a discussion with the management and the customer of the LinkedIn India. So on all those bases, they have considered that the CEO of LinkedIn division as well as the CEO at the top level, which is ultimate holding company, becomes SBO, since he both are exercising control or significant influence, even though they do not have any shareholding in the company, which makes them SBO. But since they are exercising control, they shall be considered as a SBO under this rule. So with this LinkedIn India, there are few, as we discussed, there are few this order, they are challenging the corporate practices, which is almost prevalent in every big houses. So appointing employee of a ultimate holding company in a subsidiary, I don't think so becomes a nominee director, because the concept of the nominee director is very different. It is to take care of the interest of the minority shareholder. It is not that because if you are a holding company and you are appointing your employee into the subsidiaries, you are already in control. So you cannot be said that you are appointing a nominee director. And on the same basis that non board members in the board meeting, so only participating in any meeting or as an invitee, even don't have a right to vote in that board meeting, does not constitute that you are exercising any significant influence. Authorization of bank account is another example that also prevalent in general corporate practice, that if a bank account is operated by the employee of some other company, does not make you SBO or exercising significant influence, because authorization must be always done through the board resolution, and it can so it means you have a supervision, board has a supervision of that authorized signatory. Another one is interaction with the group CEO, with the employees and customers of your subsidiary company. Also does not make any good ground to consider it as a SBO, since a group CEO always guide the employees of its own company where he is appointed, formally appointed, and also it provides a vision or mission as a group level. So I don't think so that interaction with the group CEO makes you or consider you as a SBO. Then all these the powers vested with the CEO vis-a-vis control. The this ROC order fails to distinguish between the powers exercised by a person who is not having any kind of office in the company, vis-a-vis powers being exercised by CEOs or MDs, which by virtue of holding that office, uh, as a CEO. So there's a under the Companies Act, even under the Companies Act, CEO has a wider power to control the affairs of the company. If CEO is not in his or her capacity, but the office he occupies vests with the control and significant influence, which is always subject to the supervision of the board. Otherwise, if we take away all those powers in order to prevent from this SBO role, then the role of the CEO becomes useless, because he cannot exercise any power. It is only the name he will be carrying. So under the SBO law, the objective is very much clear, that it is to identify individual as a SBO who exercise autonomous and absolute control and significant influence without any restriction, which should not be attached to any office. SBO so identified shall remain in control till the time he wishes to. If let's suppose if you make any CEO to be a SBO, So that CEO can be removed by the director, by the shareholder. If you remove that CEO, then the powers or the control he is exercising will automatically get removed. So, in my personal opinion, that CEO per se should not be considered, because the powers he is exercising, it is a power given by the board and shareholder, not by himself he is exercising. So another example or the order we will be discussing is the Samsung SDI India Private Limited. So in this case, the bottom of the pyramid, that is Samsung SDI India Private Limited, that is the holding Indian reporting company that is subjected to SBO rules, and ROC Kanpur has levied a penalty. It says that SEC Korea, that is a listed company, is exercising or is having a is ultimate holding company, and in that ultimate holding company, the family members of Lee Jae Young is exercising a control. Even though in SEC we can very much found out that the family members, either himself or through its corporate, are not having any majority stake in that SEC. And there is one more ground on which they have considered that the CEO or director of the reporting Indian company, who is who is they have declared that CEO and director, Mr. Myong Gyu Choi, as a ultimate as a SBO, because they have found during that correspondence that in a certain bank account he is declared as a UBO under the RBI KYC norms. However, in the RBI KYC norms is totally, first of all, it is totally different from the rules so prescribed under the Companies Act. It is totally different. The determinate factors, parameters of identifying SBO is very much different. And they have they also have one provision that first of all, the PMLA rules provide different parameters. They talk about direct controlling and exercising control. In case nobody is exercising any controlling any ownership or exercises control, then for the purpose of compliance, they consider any senior officer as a ultimate beneficial owner. So on that ground, ROC has taken that since you have considered the CEO or director of that Indian reporting company as a UBO, then it shall automatically be considered as a SBO under the Companies Act. And they have under the KYC norms, there is one more provision that in case if there's a listed company, then under the KYC of norms under PMLA say that in case of listed company, you need not to identify any SBO. That is the KYC norm, that is not actually provided under the Companies Act. However, on the basis of the UBO filed by the company to any bank, they have considered that on that declaration that you also be subjected to SBO under the Companies Act. And they have also considered, while declaring them as a SBO, they have considered one concept called that the largest shareholder, that they are of the view that the largest shareholder will always be in a position to control the companies or its step down subsidiaries. So this concept is not there, though it is there provided under the order. However, no such rules or the criteria is mentioned under the SBO rules. So on these grounds, the KYC norms or the UBA declaration and the largest shareholder concept, on these grounds, they have declared the two persons as a SBO of Samsung. There's one case law with respect to IDER PWI communication where the company failed to identify the two individual, that is Ramasena and Mr. AK Sinha, as a SBO. So in that case, they have found out very aptly and in accordance with the law, and these companies have failed to furnish a declaration. But while considering them as a beneficial owner, they have formulated one shareholding, which is an indirect shareholding, in the last column, where they have calculated the indirect shareholding of the individuals on a proportionate basis. However, the proportionate calculation while calculating the indirect shareholding is not provided under the SBO rules. So they are SBO as per the SBO rules, but the indirect shareholding so calculated in the order does not find any mention that any company need to calculate that indirect shareholding in this manner. This is the last one that is called Leisure Resources Private Limited. This is a case of pooled investment vehicle. So Leisure Resources Private Limited, if you see, this is a reporting Indian company who have a web of shareholding through different corporates. If we look at the end of the, if you look at the top of this, then we found that Comvest Investment Partners VLP and Comvest Investment Partners VALP as a pooled investment vehicle registered under United States of America. So they are in this pooled investment vehicle, they have a general partner, which in itself is a entity, a body corporate, and they have appointed one investment manager. They have appointed an investment manager called Comvest Advisor LLC. And the CEO of that investment manager is Michael Falk. So, so in this case, ROC Delhi, I suppose ROC Delhi has considered Mr. Michael Falk being a CEO of the investment manager as a SBO under SBO rules. So if we look at the rules, then we do not find any kind of condition that the CEO of investment manager becomes a SBO. In fact, the CEO of the pooled investment vehicle can become SBO if your investment manager is a body corporate, instead of you making a CEO of investment manager as a SBO. Here, the things not considered that SBO rules restrict only to individual who is either general partner or investment manager or CEO, who are individuals of a pooled investment vehicle. The CEO of the pooled investment vehicle is considered as SBO if the investment manager is a body corporate, but not the CEO of the investment manager itself. I think ROC has not considered that the investment manager works in a very professional capacity, professionally, and they look after the investments of their clients. If they themselves become a SBO, then it's a conflict of interest. If you consider them as a SBO, it means you are controlling you are controlling each and everything. But they act in a professional capacity. In the ROC orders, we found that some ROCs has a levied penalty under subsection 5 and also subsection 4A they have also invoked. But there's a confusion that whether subsection 5 and 4A are interlinked or whether they are independent to each other. However, if we read the section, then 5 says that if you have even if you have a doubt or reason to believe, but that reason to believe must be on the basis of some material. If you have a reason to believe that Mr. XYZ is a SBO, then your obligation triggers. If you are think that nobody is a SBO, then obligation doesn't trigger. And there is a whole process that you need to give a notice to that person who you consider as a SBO, and ask for the reply or a clarification, or if he is a SBO, then he will declare himself as a dispute. However, in subsection 4A, it the language is such that company is under continuous obligation to identify SBO. So it is here very difficult to understand whether five section 5 or the process of 5 is a continuation of 4A, or 4A is different from 5. So because under 4A there is no process how to identify SBO. So there is no clear cut just like we find in 5. So these are we have prepared was one table wherein we have mentioned that some ROC, in fact, ROC Delhi has invoked 4A, and somebody has not invoked 5. So amongst the ROC, there is no clear cut answer that whether 4A is a part of 5 or both are separate. That it can be seen from their order. Some has invoked 5, or 4A is kind of all time obligation or continuous obligation. So if ROC Delhi has invoked both the section, considering both as a separate subsection, separate compliances. So now with these orders, now considering the kind of diligence carried out by the ROC at their level, the kind of situations they have considered while passing these orders. So what precautions, what kind of understanding you can take from this order, and in not to be under the radar of the ROC, you must what precautions you can take to ensure the compliances under this SBO rules. So first of all, you must see or you must carry out the thorough diligence that what is the structure of your company or your group. If your company is not indirectly owned by any body corporate, and if that body corporate, if somebody owning that body corporate, if that individual is exercising any kind of control or a significant influence, then it should be looked into. Then if when you identify somebody, then there must be kind of communication with that person, or that person who you have apprehension that he or she must be a SBO. Then whatever be the communication, you will keep it and maintain it for the future purpose. If somebody from the adjudication department in the ROC asks for some kind of diligences whether you have carried out, then it must be handy to make them available at the time of adjudication process, that you have carried out diligence as per the law. And further, you must also update your regular interval. There might be possibility that the shareholding of your company does not change, but the shareholding at ultimate holding company or at a group level, if changes, that it somehow may trigger the declaration, or may change the declaration of the existing SBO. The fourth one is the verification of the information. Then you also verify the information. You do not just take that information as it is. You must verify the information, that whatever be the declaration or whatever be the reply that person has given, you must verify it from your own sources in the public domain, either in India or outside India. Then if any information is received from that person, then take steps to identify by furnishing band 4. If 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 any reply is not received, or you are not satisfied, then it's very hard. Then you are under obligation to apply to the NCLT to take the corrective measures. And also you need to have internal policies and training in order to identify SBO, not under this Companies Act, but also under the different rules, whether whatever what we are filing as a declaration under the PMLA, whatever be the declaration we are filing under uh, RBI KYC norms. We need to consider all those before filing it to any authority or bank. Even if still you are confused, then always there's a scope to take the independent external opinion. What is the importance of the band 4? So based on those in these ROC order which we discuss, these here the ROC find that they have not acted diligently. They have not even tried to try to demand for some kind of declaration since the SPO rules comes into effect. So it is very important to note that the first onus is on the shareholder to inform that he's not SBO. Okay. However, it is always the obligation of the company. If somebody is not giving, then the second onus comes on to you, that you act diligently to find out who is the SBO, and especially ask declaration from that person if he is a body corporate, if he is owning at least 10% share in a company. That's it from my side, sir.
Okay. Thank you, Nitesh. Thank you very much for giving the detailed explanation of the entire SBO process and the process and the issue case law which has discussed. Now, uh, as you are aware, that these are the points which are really complicated, or no doubt, the compliance issue, interpretational issue, and there should not be any mistake. Can you remove the slides, Nitesh? So let's take the view of the person who, because majority problem is coming relating to international companies, MNC companies. So I will request Akhil Prasad that he can share his point of view relating to the SPO, because he has worked in various jurisdictions, his companies across the world, and he is managing these legal part and compliance part. So Akhil can guide us and tell us that how complicated the system and how to take the, the route which can be make this particular compliance in an easy way. Over to you, Akhil.
Thank you, Pawanji, and thank you, Nitesh, for excellent overview so far on the legal aspects. First of all, I would like to add a few things. When I read the Samsung order versus the LinkedIn order, I think one of the commonalities is that both of these companies did not file a Bent 2. They did not disclose who the beneficial owner is. So that is something which comes out very clearly from the order. The second thing which I would like to highlight is on the significant beneficial owner. We read in the Samsung order that there has been references that when you open your bank account, in the bank account, I think the company opened a bank account with Citibank, where the company made a declaration about the SBO. So one thing which is very, very critical for us, as working professionals, is that whenever there is a new law, whether under the Companies Act, and we are custodians as company secretaries of the Companies Act, we have to immediately make a larger group, and that larger group should also have people who are from tax, who are from finance, and then we have to first think through as to what have you have all of you as the functional owners from finance and tax made some similar filings, because it was very glaringly evident that while the company in Samsung is taking a position that there is no SBO, but when they are opening a bank account with Citibank, they are in fact making a declaration that there is indeed an SBO. So from a compliance standpoint, to your list, Nitesh, I would strongly recommend we should definitely include that on such things, collaboration is better. And we have to understand, because company secretary may not be looking at all compliance of all laws, although under the act it is required to be so. But from an operation standpoint, there has to be a lot of coordination between various functions, especially on these kind of filings. Now coming and I have read just two of these orders. I have not read the other two about the pooling of funds concept. But what it strikes me between LinkedIn and Samsung is, uh, if you were to ask me as a general counsel, which of these two do you think is contestable? Um, Samsung to me looks less contestable compared to LinkedIn. And why I say so is because in Samsung, at least there is, when I see the pyramid in the order, pyramid of shareholding in the order which has been framed by the ROC, it very clearly says that it is owned by a family in Korea, and there is a direct link of a shareholding which exceeds 10% and 25% threshold. So there, unless Samsung is able to establish some very concrete evidence and rely on some certain very concrete facts that that shareholding does not tantamount to a significant control by the promoter family, it seems to me that Samsung seems to be on a back foot. But if I look at the order of LinkedIn, where it's a crisscross, a typical multinational setup. And when I say about a typical multinational setup, I mean is typically the companies that I have seen, uh, the big companies, say, for example, a Unilever, for example, a Suzuki, for example, a General Motors, for example, other companies which are global companies, usually you will see that there is no one person who is a substantial shareholder. And I think in our Indian regulation, 2% holding is also anything which is above 2% also tantamount to a substantial shareholding. Uh, Most of these companies, you will see that they are listed in an overseas jurisdiction. Um, they are no longer a promoter-driven group, although the name may have a name of the promoter, like a Suzuki or a Toyota. But at the top, you will see that these people perhaps have a significantly less shareholding, um, but they are involved in a day-to-day management into the affairs of the company. So, from a LinkedIn order, the company is being owned by LinkedIn Corporation, having shareholding in LinkedIn India, and then Microsoft holding in LinkedIn Corporation. But then the reasoning for making that Satya Nadella and the CEO of LinkedIn exercise significant control perhaps looks debatable to me, because a right, whether there is a contract, whether there is some kind of an agreement that such person has a right, in inverted commas, to control the whole of the world, or simply by being a CEO or a director of a parent company, uh, entitles them or classifies them to be that they are exercising a control. The other thing which perhaps is missing, and I'm pretty sure that the jurisprudence will develop, is whether a Satya Nadella or the CEO of LinkedIn alone or together jointly can exercise a significant control, because most of these companies I see, they have a very elaborate, uh, what we call a operating matrix, and that operating matrix is a mixture of many layers of management authorities. So whether Satya Nadella and the CEO of LinkedIn has a right to control each one of those metrics structures. Maybe not, and that is perhaps something why I say gives some room to debate and challenge the order of the ROC before the legal forum, and we will see in future that how this jurisprudence develops. And it is very, very rightly needed, because we need a set of guidelines in this country where such kind of orders are not at the whims and fancy of the regulator. I think the role of the government should be that yes, there is a law, but very clearly identify what is the intent of that law. So if the intent of the law is to disclose a significant beneficial owner, well, that is good. Only in those cases where it exists. But let's not try and find people under the garb of Indian regulation to identify such people. And the regulator's job is, because they read something on the LinkedIn, because they read something on the website of Microsoft or LinkedIn, they come to a conclusion that reading such kind of information in media and press news, they are putting that into a legal document as by way of an order, to make a conclusion that, because LinkedIn said this, because a social media post said this, because the website says this, it's a degree of control. So those kind of things perhaps will need to be either decided by a judicial authority in India, or I think it's the role of the government of India and the related departments to bring about some clarity as to why and what is the intent of seeking such information. The other question that I have is, if there is a significant beneficial owner, and Pavanji, you very rightly highlighted that it's an international thing, but yes, it's an international thing, but what is the purpose of getting such information? Are we going to tax those individuals in India? Are we going to make them accountable for the acts of omission and commissions of the board of directors of the subsidiaries in India? What is the purpose and the objective of identifying such, people who are significant beneficial owners? I think there is a lot of thinking that needs to be done, and I'm sure the law will take its own course. These orders will be challenged, and as I said, the guidelines will come, and I hope to see a lot of more clarity through various judgments. The other thing also about operating off bank accounts. So today, it's a global workplace, and companies operate through outsourcing. So a big multinational company or a big Indian company which has parent company outside India, there is a lot of outsourcing. So companies outsource their contract management. Companies outsource their finance department. Companies outsource their HR department. Companies outsource their sales department. Here, in this case, because this finance or bank accounts were being managed by a parent company, is that the reason that people are saying that the SBO is with the parent company? What about if a Genpact were to operate a bank account? Will Genpact become a SBO of a company which is completely unrelated because it is managing the bank account or the financial statements of the company? So I think there is a room for a lot of challenge in these orders, and it is good in a way that these things are happening. The ROCs are taking action, and these will be challenged before the court. And only then I would think that a clear-cut line will emerge. And I think it's a dual role. I think both from the judicial point of view as well as from the lawmakers' point of view, to perhaps bring about more clarity about the purpose and the manner in which notices are being issued to corporations. I think that is, Pavanji, I would like to say as my observations on this particular regulation and the SBO notices that which are being issued.
Oh, thank you, Akhil. You have rightly pointing out this bank account point of view, and the regulator must think on this aspects also, because the way law is changing, the situation is changing. You have to follow that part also. because today outsourcing is there, no doubt. And when you open the account on behalf of your client, you can't become the SBO. But one point, Akhil, I want to understand. You are saying that in India, what is the purpose? But the purpose of the entire world is there. So, what do you think that USA, UK, EU, that they have the purpose? India is following the same part which is international law is prescribing. So, do you think that other jurisdiction has some different purpose also?
I have not analyzed their law. I have not analyzed the US or the UK law. Um, but to me, identification of an SBO under Indian context remains unclear to me. Because when you open a bank account, why are you asking who the ultimate beneficial owner is? So I completely agree. When your KYC is not able to do it, when you are not able to identify a corporate, I understand. You do a further drilling down as the SBO, but for every company, and if you are a well-known company, an international company, a listed company, why do you need this kind of an analysis? So why would somebody ask? For example, let us take a very small example. A proprietary firm, and that proprietary firm is bidding for a contract, say with a Suzuki. Suzuki would like to know what is the KYC of that proprietary firm, who owns that proprietary firm. So you need details about the proprietor. But the moment you say that Suzuki is being supported by a big corporation like a Motherson, why is the question of an SBO? That is
Okay.
not clear to me. That is not clear to me under Indian context. So if you have a profile, if you can go so anybody today can go and see the SEC filings of any US multinational company. So why do you need a SBO? That
Mm.
that is not clear to me.
Akhil, I just there's a very simple point. You have company, you are managing, and you have multiple people. You have a professional, you have an outside consultant, anybody you can have. But I just want to know, an Indian regulator, that who is the natural person behind this company. Now, everywhere you can say that this company holds this cross holding company is holding this, but ultimately somebody has to manage this. So, who is that person who is ultimately managing this or owning this?
So Pawanji,
So,
under the Indian context, we have a holding company, a subsidiary company. A holding company is outside India. They have Indian subsidiaries. Disclosures are there. You're filing all your returns. If so, it's like what we had a concept earlier called vanishing companies. So
yeah,
in those times when there were these kind of vanishing companies, when they were not filing returns, you should go after them to find out who is the ultimate owner. But you apply the same logic for a company which is completely diligent, filing its return, having auditors no qualification. It looks unreasonable to me. That why are we
okay,
using the same yardstick for a company which is 100% compliant, has invested, millions of dollars in investing the compliance processes, uh, making all those returns. Even then, you are looking at them with the same lens as somebody which is a vanishing company. So for a
okay,
vanishing company, apply some tighter norms, but spare other company which are at least diligent.
okay, 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 okay. Ankit, what is your view on this? Then I'll come to the question answer.
On the cases.
No, no, overall view. Cases, the discussion, what uh, Akhil has said, Nitesh has given presentation, these two cases, overall
Mhm.
view. And you are
Sir, I
interacting with
think
client.
there is a need of to understand the provisions from both the sides. Like for example, one of the presentation slides that we mentioned is talking about Ben 4. So it's a very simple compliance requirement under the law. And while most of the orders that we have gone through, there was a case that companies have not even served Ben 4 to their corporate shareholders with a view that there is no SBO or companies not responding with any revert. But at least that is the minimum requirement out there under the law that one should do. So far as the requirement of identification of SBO is there, I think in most of the cases, the challenges that we've outlined is with respect to companies where either the holding company is publicly listed, as it was the case in both LinkedIn and Samsung, and in various other cases where you actually are in a bit of difficulty to identify who is actual person because there is no actual shareholder. But what we intend to convey through this presentation or even through the orders that they are issued by ROC, that if you go to the intent of FATF, SBO, even the UBO, the actual objective is to somehow find a way to find a person who is hidden behind and who is the real guy taking the shots. In cases where there is a professional CEO or an MD or some with something I think that is something which is very well known to everybody. This is not someone which is even the regulator wants to know that he is the SBO or not. The objective is to find persons who are behind the curtains, who is not by plain eyes. You can find out that these are the persons who are making the shots. If you see in case of LinkedIn, any major corporation, you are always aware there is a global CEO who looks after the affairs of the group as a whole, and through his own governance structure which they've established within the organization, there are different levels at which there are different reportings and everything's are being done, and there is ultimately the CEO. This is well aware fact and everybody knows it. I don't think the intention is to disclose the name of that person to the ministry, okay, that he is the CEO and he is exercising the significant influence. The identity is to find somebody who is other than the CEO, is who is through that CEO is trying to make that shots or is taking all the real decisions. That is the whole concept. Even in case of bank accounts also, the purpose of EBO is to actually, in terms of KYC, is to find out the real guy who is behind it. And in case of UBO, there is also a provision which is not in case of SBO, that in case there is no UBO, then you have to disclose the name of the key managerial persons of the company. In case where companies disclose their name of the MD, CEO, because there is a provision in the declaration itself which you file to the bank of SBO that if there is an UBO, you disclose the name of the UBO. If there is no UBO, mention there is no UBO and outline the name of the key managerial person. This concept is not there in the Companies Act. Another challenge, I think, which is on account of actions where companies have not filed Ben 1 and ROC have been issued notices to those companies, is that there can also be a provision in case where there are companies, non-individual shareholders, which are holding more than 10%, that those companies can file to the ROC saying that there is no SBO. Because as of now, in case companies who have not filed SBO, ROC is not aware of the fact whether there is an SBO or not, and then he goes into investigation, calls for information, and does its own review, hearings and other things. He may conclude, he may not, but all these things, a lot of time. If companies on its own have disclosed to the regulator that there is no SBO, they've already looked into it in terms of their own diligence process. That will also save a lot of time for both the regulator, and it will also keep the companies on their toes that they have to give this declaration that they have given the benefit to the relevant shareholders, which have communicated to them that there is no SBO, and then in line they have also communicated the same to the regulator. I think that would also save a lot of time. If you look into the earlier rules that were issued, the first set of rules that were issued by SEBI, sorry, by the ministry, that in some situation tends to cover the intention of the orders which were issued by ROC. But post the new rules, the situation has completely changed, and they have gone more into the manner in which the steps have been outlined in the explanation. And the point of concern will always be control and significant influence, because those are which are subjective issues. Shareholding is objectively, can be very well objectively defined, identified, who is your shareholder, who is or not. But significant influence and control is something which you can only ascertain if there is a very clear-cut agreement, or otherwise you have to go in detail to look into the structure of decision making, who is actually involved in the decision making, who all needs to be consulted before company comes to a decision. There are a lot of things that need to go into it. Both the orders in sum and substance is trying to cover that situation only of persons who can or who are in a position to be in exercising significant influence or control. But in the context, as I mentioned, CEO or MD is something I don't think the intent is to cover those persons. Otherwise, it would be very easy for everybody to file the name of their MD, even in the Indian companies, that there is an MD and he is exercising significant influence, or there is an MD or CEO in the parent company, ultimately whether it's a listed or not, who is exercising control or significant influence. So I think both the orders would definitely be challenged in court, and a lot of clarity would be there once the matter is heard and decided by the courts.
Okay. Uh, okay, Ankit. So now, can I take up questions which has come?
Yes, I think we have too many questions like always, and we'll be happy to
Yeah.
respond on.
So now, Akhil, you can also answer the question wherever you think. In case of complicated holding structure, how do we ascertain the SBO, Ankit?
It's a very generalized question. What is a complicated holding structure where itself needs to looked into?
We
As
mean
to what
the
would be a
cross
complex
holding to
structure.
one company to another company is holding cross.
Sir,
And
I
then,
think in cross holding, we have already mentioned that in cross holding, ultimately there have to be someone who is running the show. All the companies within their own complex structure cannot run. Ultimately, if someone has formed those companies and then change the structure into a board interlock. So we need to find that individual. It would be in some corner of any of the companies. We could be looking into it. But complex structure is it's we have to look into the facts of the cases to determine to what extent there is a complexity. And but ultimately, shareholding, it's very easily identified. Significant influence and control. I think some of the factors one can look into is to participation in the decision making, if whether that person is in any way influencing the decision making or is indirectly participating in decision making, or through some other ways, through other persons is directing certain actions. Those things can be looked into from a perspective of a significant influence or control.
I think a
okay.
simple answer to that would be, asking ourselves as a company functional representative, where are the mundane decisions taken, or day-to-day basis are you going to your parent company for those decisions? If a simple answer is yes, then you are in trouble on SBO.
Okay. Whether a company holds 15%, a private company will be considered as significant beneficiary owner?
Sir, a holding company, sir, we have to look into the shareholding of the company that is holding 15%. Company is can never be said to be an SBO.
Okay. Is there a joint venture public limited company with two promoters companies holding 49.94% shares, each of 5 individual shareholder holding 1 equity shares each? Will when post 2 will be required to no one is holding majority shares?
Yes, if all others are
Can
acting as
joining
if all others are acting as nominees, then it will be. Hitesh, you got the question?
I think they are talking about if a reporting Indian company in itself is a joint venture company of two different company.
Okay.
So we need to look at the joint venture partners, sir.
Okay. I got a call from Mr. Santosh Kumar, so he want to join. So
Okay.
that's why. Yeah, okay. If a company has filed Ben Post 2 from form, but did not get the SBO ID on email, now there is a change in the SBO. For this SBO ID, it needed to be pre-filled in Ben Post 2 from. How the SBO ID can be retrieved?
I think you can raise a ticket to help desk. They will definitely help you in getting the ID.
Okay. In the above, the promoter company also have there's no SBO holding more than 10% holding.
Sir,
This question in case of complicated holding structure, how do we ascertain SBO? उसका एक subsequent question है. In the above promoter companies also there is no SBO, there no UBO holding more than 10%.
So then there will not be any SBO considering the
But
fact.
we also look at the concert. If any group of individuals owning that company, promoter company in concert, and they are owning more than 50%, then all become individual, all who are acting in concert become SBO.
But using the LinkedIn case logic, then ROC will try and find out somebody like a Satya Nadella in that company.
Because Bakil, I just want to ask about this case. the Satya Nadella matter, we are aware that he is the person at the mercy of the board. Tomorrow, the board can decide that you can.
Correct. And Pavanji,
Okay.
I said the same thing. Satya Nadella, I'm not a Microsoft general counsel, so I don't know. But Satya Nadella, in a multinational environment, there would be several checks and balances before a decision is made. So
Yeah.
it's not one person deciding and calling the shots. Simply you are a CEO does not mean you are in control. There are several checks and balances in these companies.
Yeah, Akhil, one more thing which you can highlight this, that in Indian concept, you may confuse because the person who is a holding or controlling things, he may be the promoter, actual promoter. But
Correct.
in international scenario, we are aware that their concept is totally different. They are managing on the basis of the corporate structure. You
Correct.
are, and the board is a supreme power. We have seen the AI, the recently the Chat GPT CEO. People were thinking that this person is managing everything he has made, and they removed him. Okay,
Ah.
so this type of example, or you can take the Apple
Sir,
example.
sir, you look at our unicorn examples, no? People who have been calling the shot, they are thrown out
Huh?
immediately. We have seen
Yeah,
what happened in Paytm. We have seen. Suddenly
yes,
you
yes.
ask, so what? So things like these happen. So how can you say that these people are in control?
So I think there is a need of rationalization. When we want to promote the corporate culture, we have to understand the corporate aspects also. Corporate is not connected to anybody. It's governed by the board. And second is, you have a multiple role. You may be shareholder, you may be employee, you may be board member, you may be whatever. Same person can be, because we have seen the various case law. But I think as the regulator should realize the real concept. They should also not influenced by the way that, okay, Akhil is managing Boeing, so he's the SBO of the Boeing. So that because he's going to everywhere, talking to everyone, and doing this, but he is not holding shares, or if he's holding shares, he's holding very minimum share, and his decision making is depend upon he's fulfilling others' point of view.
Sir,
So
I hope ROC does not look at my Facebook and my LinkedIn accounts.
you are right, and that will happen. That will
Yeah,
happen to make. So we have to understand the control concept of the corporate should be in a different way. So there is a need that you ask that who is the person behind this. But suppose somebody is not there, just you don't put that anybody that he is managing show, so he is the SBO. So we have to
absolutely.
understand that aspects. Yeah.
100%,
Okay.
100%.
Yeah. If the holding company is a non-profit company in USA and does not have any shareholder, then how to determine SBO? Akhil, you can tell.
If a holding company,
Holding company is a non-profit company in USA and does not have any shareholding, then how to determine SBO?
A US company
Well,
does not have shareholding.
they are talking about the Indian company. There is a
so,
subsidiary
but
company in
then
India.
way can be to identify their governance structure. In the governance structure, is there someone who is having the control?
So the question is, non-profit company in USA can make a profit company in India. That's a one part of the subsidiary company. There is one. Second is, suppose they are making, so they are non-profit companies, so there is no shareholder, nobody is doing this. So who will be the SBO in India?
So, sir, India में Tata Trust है ना, non-profit. Tata Trust hold all companies within the Tata Group. Tata Trust has all non-profit making companies. So
Okay.
if you use a similar concept in USA, I don't know why it should not be that a non-profit company in US cannot form a profit-making company in India. There is no relation between the two. They can, I think.
Okay. That's right.
Sir, on the
Okay.
similar line, even a reporting Indian company is also a non-profit company without share capital. There can also be happen ki 10% criteria is not fulfilled, but through other structure and through other criteria or parameters of control and significant influence, we always have we cannot just write it off any NPO who's reporting company without share capital in
Okay.
in India's perspective.
Okay. There's less than this. Oh, good. Okay. In case no person concentrating or acting concerned having 33% shareholding, can we say that no SBO and no need to file BEN form?
Yes, sir. Yes, sir. But it is very difficult that if somebody says all three are in partnership, incorporate a company, and that company is not, they are not acting in concern. It's very difficult to say. Otherwise, if we go by the rules, if nobody is owning more than 50%, we cannot say that he is a SBO. But it is also at the same time very difficult to say that all three peoples are acting in concert.
Okay. Does MD of the organization come under the significant influence? There are total 5 directors and don't hold any shares. Same example on Nadella.
I don't think so.
Okay. So when you say no, not say, then how this LinkedIn order is correct?
But LinkedIn order is they have looked into the at the top of the parent company who is at the helm of the affairs, not
Okay.
at the immediate Indian operations.
Okay. My
सर
2% stake.
मेरे हिसाब से तो चैलेंज होगा लिंक्डइन ऑर्डर.
नेचुरली होगा,
हाँ
बिल्कुल
डेफिनेटली
होगा.
आई थिंक वो तो होगा ही. मतलब क्या पता अभी तो हो भी चुका हो. वी आर टॉकिंग फाइल हो गई एप्लीकेशन तो आई बिलीव अभी तक.
करेक्ट.
Okay. My 2% stake is with a foreign body corporate shareholder. There are reverse reserved matter. However, that entity and the all shareholder decision taken by, I think. Swati, you have to just
Sir, I
write
think
the
if
question.
there are such powers like reserved matters, one can look into from the perspective of significant influence.
Okay.
Because it is very clear, just having reserved matter rights is no control. There are various cases on it, but then it can be looked into from perspective of a significant influence, because in that case, that person, body corporate, would also must be having a board seat.
Okay. Do I need to check body corporate for my SBO, considering they have only 2% shareholding, and there are reserved matter where their consent is mandatory? Same question.
I replied that.
Yeah. Okay. Mr. Y is the right to appoint a director in a listed company and having more than 15% shareholding directly by the virtue of. Can he be considered SBO?
He can be considered SBO from perspective of significant influence, considering he has a right to be appointed on the board. We also need to look into other surrounding circumstances.
Okay. What is the deciding factor for deciding the control in the absence of any agreement?
So like shareholding, so if you, while there are various, it's a debatable topic. One of the point which Samsung order covers is that, for example, in a listed entity, a person holding a highest chunk or largest chunk of shares will tend to be in a position to exercise control, considering the shareholding is spread widely among the other shareholders. So if you are holding 50%, then there would not be question of you looking into the control. But if you are in a position through other means where you are holding significant shareholding and shareholding is very spread, then it is not naturally that you would be exercising control, but deemingly you can be said to be in a position to exercise control. Then other ways can be board seats, rights, or which have been either given to you. Those things can be looked into.
Okay.
सर इसमें एक पॉइंट और है सर. Being a larger shareholder, calling it as his controlling, it's very debatable, since we have an recent example of Religare, where Burmans are the largest shareholder, but they are not being entered into the board seat or kind of doing the completion of the public offer. So
that example,
there is a slight difference because there the management is averse to the idea. But generally, if you see in other corporates where promoters are holding such a stake, they are also on the board in one way or another way. So therefore, there's slight difference between what I said and what's the case of Religare.
There's so many other examples also. Our system, there is an open offer in the company, person acquires a 31% share, but he was not interested in any board seat. He wants to. So you can find this type of so many examples. Achha, whether a company holding 15% a private company will be considered a significant beneficiary owner?
I think the question is why all these questions which have been asked, they are saying company is a SBO. Company can never be an SBO, an individual has to be an SBO. You need to look into on the back of that company if it meets the conditions outlined in the rules. 15% is a fit criteria for the triggering
So
of
you
the
meant to
SBO
say
provisions.
15% this company is holding, but who is holding this company's
Yes, then you have
interest?
to look
That
into from the individual perspective, who is majority shareholder, or if a group of shareholders holding majority, you have to look into from that perspective. Company can never be an SBO.
okay. Please share the. We are sharing this presentation to everybody. Don't worry. Then any update on these judgments, especially LinkedIn and Samsung, has been further challenged?
No idea as such, but we'll definitely look into it and apprise the participants through mail.
But they have the option either to appeal to the regional director or to the straight away to the Delhi High Court.
Okay. Is there a company which 50-50 JB and confirmation letter received from both the partners that there is no individual holding 10% or more than 10% shareholding? Do we still need to file the BANPOS 2?
So the question is not on 10%. The question is there any individual who is holding majority shareholder in either of these companies? It is not
So,
of
Ankit,
10% of these companies. The companies, if it is a 50-50 joint venture, then in either of these companies, is there any individual who is holding majority shareholder, either individually or along with other persons? That needs to be looked into. Person who is just holding 10% is not a criteria even outlined under the rules.
Okay, so Ankit, very clearly defined that any company can hold any number of shares. You have to first test that who is holding 10%. So if anybody who is holding 10%, that will come under this category. But the question is, if this is the company, then you have to see behind this show who is managing this company. I think that is a simplified process.
There might be cases where a company is holding less than 10%, but still there is an SBO.
Can you give an example of some?
For example, I am holding a share in a company. I am holding 4% or 6%. And then there is a company which holds 5% shares in the company. I own 100% of that company. So my total holding is 11%. I have only disclosed 6%, which is a direct shareholding. So then I have to file a declaration for 11% because that is my actual holding in the company.
Okay, so directly or indirectly, what you are holding?
Yes, from the individual, you have to check.
Okay. If there is no UVO in case of bank KYC, can we file any declaration to the bank?
Sir, I don't think there is a requirement of there is a concept of any declaration. I have seen the form. In the form, if you don't have any UBO in terms of the requirement of the law, then there is a declaration in terms of who are the key persons in the company who are managing the affairs.
Okay.
So you have to, I believe, disclose their names.
Okay. If LLP partnership firm is a shareholder of a reporting company, then all the partners are considered as SBO?
Yes, as per the law, all are considered.
A listed entity, generally even with 10 to 15% shareholding, they will be single largest shareholder in company and will hold the position in board and can influence the board's decision. Can he be SBO of that listed
entity? Yes, he can be.
entity?
It needs to be looked into. He can be.
Okay. If the trust holds majority share in the listed company and the listed company holds 18% shares in the private company, will trustee be considered SBO?
Yes. If it is a discretionary trust, yes. If it's a specific trust, then the beneficiaries will be considered.
Okay. If the national holding, if the holding company is a non-profit, I think this we have already told. If a reporting company is a partner in LLP, whether these shareholders having more than 10% will be SBO or only one of them who holds more than 10% shares.
There is no concept of 10% holding to recognize an SBO from an individual perspective.
But Ankit, why people are confused and why people are asking these type of
I don't know
questions?
why they are confused, but there is no such concept of 10% from an individual perspective. The only 10% is from perspective of you giving notice to your non-individual shareholder, who then has to look into is there any SBO or not. From
Ankit,
any individual who owns just a 10% in my body corporate shareholder, non-individual shareholder, he will not be an SBO.
No,
Individually, he will not be an SBO.
Can you because I have
Sir, for example, I think Nitesh has very clearly explained in the presentation, if there is a company and in which a company holds 10% or more, and in that company, for example, there is an individual who holds 10% or more, just 10% or 11%, he will not be an SBO. For him to qualify an SBO, either he has to hold more than 50% along with other shareholders, or he has to hold more than 50%. If he is just holding 10% in that company, he cannot be an SBO. The law is very clear in a body corporate, which is in any non-individual member, from a shareholding perspective, one has to hold majority.
Okay. If a public company is going to IPO, then despite there is no SBO, stock exchange is insisting of mentioning SBO in the prospectus. How to deal with the same?
I don't think they can insist on mentioning an SBO if there is no SBO. Because as a lot of listed companies do their SHP filing where they mention there is no SBO because there is a requirement to disclose SBO. So if I can do that as part of my post-listing compliances and the shareholding pattern, and if there is no SBO, how can one insist me to disclose an SBO? For example, all our individual shareholders, there cannot be an SBO.
Okay. Would you like to know whether regional director also agree with the stance taken by ROC in LinkedIn case? Reason being the ROC order can be appealed before RD. So I think that's a matter going on. If the
yes, sir, no such order is in public domain as of now of RD against any appeal.
Same. I'm saying that's why if some order will be passed, then we will see.
Sir, Santosh ji was joining. What happened?
He told that I'm joining. Just he's completed his
Shivam, can you check with him?
Shivam, just share the link with him again. Okay. If LLP partnership, I think yes. Ankit, should the subjective test and objective test under SBO defines be read together or should we read independently?
It has to be read independently.
If a person is holding one share in a nominee holder in an Indian company, that is 0.001% and holds 16% ultimate holding foreign companies, will the holding amount to be being SBO? Because both has to be clubbed together.
It has to be. I didn't get the question correctly.
If a person is holding one share as nominee holder in Indian company,
okay,
that is 0.001% and holds 16% ultimate holding foreign companies.
So, sir, first of all, the 0.1% whatever he's holding as a nominee, then he's not holding in its own capacity. So that cannot be added to his own individual shareholding in the ultimate parent company. And 16%, I don't think will give him any right over that ultimate parent company for him to be eligible for declaring himself as an SBO. If you are talking about 16%, not 60.
Okay. This is 1/6. In the corporate shareholder, nobody is holding the majority share. Then who will be the SBO?
If there is nobody holding majority share, all are acting independently, then there is no SBO.
What are the ways to checking SBO in a company having various 4-5 layers of the parent foreign company?
So it is very clear. You have to find the ultimate holding company and then look from there.
Okay. If LLP partnership firm holds more than 10% body corporate, will it be all the partners of the firm are considered SBO as per the explanation?
Yes.
And okay. If the public company, this is would this is also. What is the way forward for other MNC which are operating as LinkedIn in India? Since there is no guidance on what amounts to significant influence and in view of stance of ROC in LinkedIn matter, should other MNC also treat global CEO as a SBO? Akhil, I think you can give answer of this.
No, I don't think so. That is by default should be the reasoning. But such companies should definitely identify who actually controls those organizations, and that person should. So the opening statement I said, it has to be evaluated with your tax and finance teams. as to whom you are showing in your tax filings as the beneficial owner, and then you have to come to a conclusion. It is a
Okay.
very, it is not an easy answer. It has to be analyzed on facts
So
and circumstances.
the point is, everybody should wait for LinkedIn and sense an order in the wherever the appellate authority is deciding, and that will be the guidance for everyone in future.
And what I
Okay.
see is people who had not filed a Ben 2, I think those companies are getting notices.
Okay.
So one has
Okay.
to analyze. Yeah.
So you can't wait for the order. You have to follow your legal advice, and you have to work out.
Yes.
One of the member is a major shareholder in a private limited company in a cooperative society. How can we find out SBO? Who will be SBO in cooperative society?
Nitesh, you can take this.
So could you repeat? Cooperative society.
One of the member and major shareholder in a private limited company is a cooperative society.
Okay.
How can we find out SBO? Who will be SBO in cooperative society?
So the structure of the cooperative society is totally different from the body or the Companies Act. I don't think so. In the case of society, anybody is owning 50% or having a control. It's a kind of housing society or any kind of limited purpose society. It does not found any mention in the rules that cooperative society will be covered under SBO.
But from a body corporate perspective, you have to, I think, apply the rules, considering it being a body corporate. And
If we consider, yes, if we
and
consider
then
as a body
from that
corporate.
perspective, then you have to see in terms of if there is a governing body, then there is anybody who is controlling those affairs, or any group of persons who
But
are
in the
acting together.
cooperative society as well,
Generally, that is the
they are
challenge.
into professional kind of thing.
Ankit, SBO from LLP, please elaborate, and from 4D to be filed as per the recent circular.
Sir, it is on the same lines as in case of a company. Just the LLP has been replaced by company.
Okay, in case shareholder are having shares in more than 2-3 companies and they are ultimately owner, still is a reporting necessary?
Yes, if there are related, for example, relatives, and two, three relatives are through different companies are holding or controlling majority shareholding, there is a requirement of an SBO filing.
If a shareholder is having more than 10% in another company of their own company, will SBO attract?
Not necessary, no.
If an Indian company is a last question, Indian company is a subsidiary of a foreign company holding more than 10% shareholding or more, say even 100% is reporting requirement as SBO by Indian company, do when one form required to be given by foreign companies?
Yes, if there is an SBO, company needs to give them Ben 4, then the company will revert by giving a Ben 1 or by explaining the reasons that why there is no SBO.
Okay, this interesting question has come. What if the companies have completed CIRP and monitoring committees appointed, however ownership is yet to transfer to SRA, successful resolution applicant? In this scenario, is there any compliance requirement for a listed company?
Sir, the compliance obligation is, I think it would arise at the time the provisions were there, because the shareholding must have been before pre-CRP. So generally CRP के केस में तो चेंज होगा नहीं, तो प्री CRP होगा तो ऑलरेडी उनकी रिक्वायरमेंट होगी ट्रिगर SBO फाइलिंग की. वो अगर उन्होंने फाइल किया होगा, उसके बाद जब SBO आ जाएगा नया, मतलब नया आ जाएगा ओनर, देन they will reevaluate and then file a different SBO form if there is an SBO.
Okay. So with this, we received around 40 questions, and we try to give answer of all these questions. Still, I think the people are confused, and which Ankit has clarified, and Akhil has also given the right prospect relating to this. And Nitesh's presentation is very clear. We will share this presentation to all. And one thing is very clear, when people were asking questions, so I was also thinking that why this confusion? The company is not SBO. The company is behind the company. Who is the person? He is the SBO, because we have to understand the purpose of SBO is to identify who is the natural person behind all these web of companies. So When you are just asking this question and when you are confused, please understand companies are not SBO. The companies behind the companies, people are SBO. So you have to just identify it and do this. No doubt, this is a very complicated things and multiple issues are there. When there is a international scenario, then multiple things are also there. Like Akhil type person who is working in international scenario and the companies, they have a companies across the world and every jurisdiction has their own interpretation. It is really tough to do this because it is impacting everywhere. So before closing this, I just want to request Akhil, just what message you want to give to the corporate world and the professional relating to this, so they should understand properly.
So my message, Pavanji, will be, uh, you know, that is what I do is to do a lot of collaboration. Don't take decisions in haste. Like the example that you gave, should we directly appoint the global CEO
Mhm,
as the SBO? I think that is
mhm,
not the right approach. I think the approach
mhm.
should be because you have to make your case. If tomorrow you get a notice, that is what is exactly what you would like to defend yourself, and that is how you should think through and then make your filing. Is what I would advise. And
Okay.
that decision has to be with your tax team. That decision has to be with your finance team, and a lot of collaboration should be taken.
Okay. Nitesh?
So, just want to know that what Akhil sir said, that we need to look at the different disclosures filing at the different forums, either to the bank account, and also look at the disclosures made by, if it's your ultimate holding company is a listed one in a different jurisdiction or a foreign jurisdiction, whatever be the disclosure they are making, they should commensurate with our records, our documents, and need to act diligently in accordance with the Indian laws. And also that considering UBO under banking norms is totally different from the SBO you are considering under Companies Act. So you need to have a kind of coordination between different departments, or a subsidiary amongst a group.
Okay. Ankit?
I think, sir, the orders of ROC in various cases have in a way intimidated the corporates, and because they are orders of such higher magnitude. So, but I think as both Akhil sir and Nitesh mentioned, proper due diligence is what is the need of the hour. We need to do proper due diligence, bring it in your minutes before the board, document it so that whenever ROC is asking you information, you are in a position to explain your position at least, so that there is no question on you that you fail to do your diligence. And then definitely there will always be a different point of view from a company perspective and from a regulator perspective. That is something which will be worked upon as and when we interact with the regulator and take it up to higher levels of courts.
Okay. Okay. So now it is very clear that this concept is gaining a momentum, and the cases and the notices issued by the ROC and then taking decision, it is also evolving law. And when it will go to the appellate authority, the correct picture will come out, and people can take breath of relief of sign when right position will come, because ROC is taking action on uh, some interpretational issue, certain things. But when it will go to the judicial scrutiny, they have to take the overall view that what is happening. So maybe ROC decision, people may challenge. RD can also pass the similar type of thing, because their hand is tight. They can't go beyond the law, and what is mentioned in the law they have to follow. But judicial system is free. They can interpret. They can tell that your legal uh, structure is not correct. You can't do this. And we have seen in the entire world the multiple thing is there: cooperative society, non-cooperative society, profit-making company, not profit-making company, LLP, where the various structure are there, and everywhere the concept is coming in between and then following. With these things, I just thanks all my speaker. Special thanks to Akhil because his wide knowledge and expertise in this area and international exposure has given the dimension of the right way which is there. And Ankit and Nitesh, they are doing a day-to-day interactive with the companies and telling them what to do, especially listed and unlisted big corporate. So their interpretation and their explanation is also very useful for all. So with these things, thank you everyone. And friends, the journey of this knowledge sharing will continue. So next Friday, 4 p.m., we'll meet again on 5th July. We'll meet with the new topic, that is SME IPO, because today, every day you are seeing SME IPO is taking new shape. And today we close our first IPO on SME, Deinstein, and it is oversubscribed by 40 times. So we have asked 22 crore rupees, but public has given 800 crore rupees. So you can understand how much interest is there in the market and people are doing this. With these things, we'll meet next week. SME IPO is a very interesting topic, and every small company can also plan whether say 10 crore, 15 crore, 20 crore they want to raise. In place of going to the bank, if they have a good business model, if they can give better return to the investor, come and take plunge into this SME market. But you have to follow compliance, you have to follow law, and you have to follow various things. So we'll meet next week. We'll discuss this. Till then, goodbye.